I'm being technologically challenged, as you can see.
So am I today. Join the club.
The name on my picture says my senior paralegal. So,
Carrie, I got you.
My name is Jeff Heller. I represent Mr. Nicholas Mittenmeyer.
Okay, let me mark you in and see. Okay, and tell me your name again.
Jeff Heller, H-E-L-L-E-R.
H-E-O-L-L-E-R. And
there's no O, Judge. It's just H-E-L-L-E-R.
Oh, Heller.
Yes, ma'am.
Okay, gotcha, Heller.
Thank you.
Esquire. All right, that's position number 9. So I have you there. Do I have any other attorneys on the Zoom who would not appear on the calendar?
Yes,
oh, there's your name. It's there now. So go ahead and mute yourself, Mr. Heller, and then we'll get to you shortly.
Very good.
And Your Honor, if I may as well, I will need a breakout with an interpreter for position 5, and the interpreters will be joining the Zoom hearing around 2:30 today.
Your Honor, actually, I'm here. I was able to join right now, so I'm right here.
Oh, good. Okay, I see Spanish interpreter. Good.
Yes, Judge. Can we please get started with the interpreter case in courtroom 3, please?
Which is position 5.
Yes, that's correct.
All right, let me go ahead and do my opening and call the calendar, and then we will get started. All right, good afternoon, ladies and gentlemen. This is the Fulton County State Court Expedited Accusations calendar for today, which is March the 16th. This is the calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them. The cases have been bound over to the Fulton County State Court. And so today may be some of the defendant's initial appearance before a state court judge. We're going to address several matters today, including bond, possible arraignment, and consideration of a possible plea offer if one has been made by the state at this juncture. The state all-purpose reset date for this calendar is March the 29th, 2022, March the 29th. So I will begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I want to also inform the defendants on this calendar that you do have a right to remain silent, and anything that you state about the facts or occurrences of your case can and will be held against you. The solicitors and prosecutors are on this call. So again, defer to your attorney and govern yourselves accordingly. And so we're starting with position number 5. Is that correct, Deputy, in courtroom 2 or 3?
Yes, you're gonna start in courtroom 3 with the interpreter case. They just still need a breakout. And then while doing that, we can go ahead and start with position.
Hold on 1 second, my volume. All right, say that again, Deputy.
While they're doing the breakout in courtroom 3, we can do position 9 with our private attorney, Mr. Heffler. Or I'm sorry, Mr. Heller. With position 9, Mr. Mittenmeyer.
All right, hold on 1 quick second. I'm having a hard time hearing. Let me, Ms. Lewis?
Yes, ma'am.
Something has come on in the room that I'm in that is causing me not to be able to hear.
Okay, give me 1 second. Let me put the those in the breakout room, and then I'll come right on in there.
I can barely hear you. It sounds kind of blah, blah, blah.
Okay, who needs to be in the breakout room? What PD had in this case?
Hold on, everyone. Let me.
Wanda Gant is the PD.
Okay.
And the interpreter, Spanish interpreter.
Ms. Lewis, say something again for me.
Can you hear me? Testing 1, 2, 3. Testing 1, 2, 3.
Down here, barely, 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 barely.
Give me 1 second. I'm on my way over there now.
Okay, thank you.
Judge, check your email.
So you can adjust the volume. Judge, can you hear me? Judge, can you hear me? Asking let's see. We're having a few technical difficulties, everybody. Just bear with us just a moment. Okay. Can everybody hear me?
Yes, we can hear you.
Okay, just trying to make sure that the judge's volume is where you can hear her. The volume went out. Okay. And I can't even see the judge now. Just bear with us, guys. It's just one of those days.
All right, say something again, Miss Holly.
Hey, can you hear me okay now?
Yes, hold on a second. Say
Okay,
something
do you
again.
need to- Okay, testing 1, 2, 3. Testing 1, 2, 3. Is it at a volume you can kind of hear, or do you need to turn it up or down? Testing, testing, testing.
Say something
Testing.
again. Hold on.
Okay, testing the volume on the speaker. Can you hear me on the speaker?
Oh, hold on.
Can you hear me okay?
You barely, but let's
Testing.
see. We're trying
Oh,
one other
wow.
thing.
Testing,
Um,
testing, testing,
I'm gonna come
testing.
back on camera. Hold on.
Okay,
I can hear
can
a
you hear
little
me
better.
now?
Little better.
Okay,
Let's try
testing,
to-
testing, testing, testing the
Hold on.
volume. Okay,
It's not working.
The volume on the
Okay.
computer not working?
we
It's
went and got a
very
sound
low and we
bar.
have it all the way up on 100. And some people are kind of muffled and low, but I think. I
Okay,
can
we may
get
have to
through it.
change rooms. We may have
I
to
hope
change
not.
rooms. If you want to come over here, my camera and everything is up, and I'll go to a different room so
If
that
they're
we can go
almost
ahead.
done, I'll run down. We're gonna check to see if the courtroom is available, and I may run down there real quick. And that's why I stopped, ladies and
I'll
gentlemen,
go
the
see.
courtroom
I'll
is
go
still
see.
being used.
Okay, yeah, Tucson, you're closer to it.
Someone's telling me they think they're about done in 2 seconds, and I may run downstairs. Well, that's the test mic.
Okay, while he's checking, we're still checking the volume.
They're done?
So everybody,
Okay, give me a second. I'm gonna run to the courtroom. They just
Okay.
finished, okay? I apologize,
All right.
everyone.
okay. Be back with everyone in just a minute. I'm right behind you.
Where'd the judge go? Katrina, you on here?
Tucson, she went back to the courtroom. You heard me?
She came downstairs?
She went back to the courtroom.
Okay.
We apologize for that. She's gonna go downstairs and log on down there. We was having difficulty with the speaker, so we appreciate y'all patience. Do anybody else need a breakout room or talk to anybody while we got time down? Everybody's good? Okay.
All right, everyone. Sorry, logistics are interesting, but we're back together again. Okay. All right. We were starting with position 5, was it?
I thought it was it 9?
It's gonna be
The
position
attorney?
9.
Yeah,
Mr.
okay. The attorney.
Mittenmeyer.
9.
Okay.
All right. And then are we doing the interpreter's case next? I think that was 5, or that needs to go into a breakout.
I think they've already went into a.
Oh, they
breakout.
have. That's even better. Okay. All right. This is case number 22 CR 001444J. State versus Nicholas Mittenmeyer. You're charged with 1 count of battery, family violence, and a 2nd count of cruelty to children in the 3rd degree, both with the offense date of March the 9th, 2022. Do you have anything pre-trial?
14 total between Georgia and Florida. Got a 06 burglary conviction, 06 arrest for assault and battery, no disposition for the battery. That's it as far as violence that I saw.
Okay. All right, that is fine. And Miss Tortorello,
Yes, Your Honor. Good afternoon.
good afternoon.
Hi. The state's recommending the following: for the battery, family violence, $4,500 surety bond, and for the cruelty to children in 3rd degree, a $500 surety bond, which would be a total of $5,000 in surety. The condition is that the defendant do not return to the incident location at 6105 Masters Way in Alpharetta, Georgia, that he have no contact with the victim, Alyssa Mittenmeyer. The first name is traditionally spelled and last name is just like the defendant's, and she is present at the hearing, Your Honor. 1 day anger management, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 9th, 2022, around 3:42 p.m., the defendant, Nicholas Mittenmeyer, did batter Alyssa Mittenmeyer by grabbing onto her arms and pushing her into the walls of her apartment, as well as striking her face with his elbow. The victim advised the Alpharetta Police Department that she and the defendant share a daughter together and used to be married. The defendant's violent acts caused the victim to sustain a bruise under her left eye. The victim's and the defendant's juvenile daughter, initials O and M as in Mary, was present during the incident against the victim. The incident occurred at 6105 Master Way in Alpharetta, Fulton County, Georgia. Your Honor, this defendant, you've heard from pre-trial, he has 8 cycles from Florida, 7 cycles out of Georgia. This makes him a multi-state offender. He has a conviction on November 27, 2006 for burglary of a dwelling with assault or battery out of Martin County Clerk of Court out of Florida. He's had various felony arrests out of Florida and violent arrests, which include battery back in 2006 out of Seminole County, Florida. A 2014 criminal damage to property arrest from the Woodstock Police Department that was dismissed. And in April 19, 2015, he was arrested for contempt of court out of Bartow County, Florida, Your Honor. The victim has advised the state that she is currently filing for divorce, which is actually the source of the violence towards her. And this is actually part of the cycles of domestic violence, Your Honor, where the abuser reacts when the victim wants to leave. The defendant does have concerns. He's been arrested for felonies and violent offenses in the past. He has a risk of reoffending, Your Honor, while he's out on bond, and not only reoffending, but committing felonies while he's out on bond, given his record. He's been charged with contempt of court and has a risk of intimidating the victim here, as he knows who she is He's currently married to her, and they share a daughter together, Your Honor. So for all those reasons, Your Honor, we do feel that a surety bond of $5,000 is more than reasonable. Nothing further from the state.
All right. Mr. Heller?
Thank you, Your Honor. Once again, Jeff Heller for Mr. Mittenmeyer. And I appreciate the state's recitation. I would think it'd be noteworthy that the last real offense was more than 17 years ago. Mr. Mittenmeyer has his own business in North Georgia, so he's not a flight risk. I'm not arguing with the state's recommendation of the amount. I think that's reasonable given the circumstances. However, I would like the court to consider contact with the alleged victim in this case, because one, I've spoken to her and she doesn't fear being around him. And they share a 2-year-old daughter. They do live in separate locations, which means that I have no problem with him not returning to Mrs. Mittenmeyer's home. But she also suffers from a seizure impairment, which requires Mr. Mittenmeyer to take care of the daughter from time to time. And I even asked her to be on the Zoom call to give her testimony to Your Honor as to how she feels at present and what she would like to see happen, just for purposes of the bond and the conditions. So if Miss Mittenmeyer is there, Alyssa?
I'm here. Your Honor, if I may interject, will you swear her in or should I swear her in, Your Honor?
I can swear her in. Ms. Mittenmeyer, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. And are you ready for her to testify, Mr. Heller, or do you have any other?
No, I'm ready, Judge. It'll be very brief.
Yes.
Okay.
I only want you to speak to the incident at hand today.
Yes, ma'am. Alyssa, can you hear me?
Yes, I can.
Okay. You and I spoke before on the phone, did we not?
Yes.
Okay. And did I ask you what your opinion was as far as having contact with Nick? Did I ask you that?
Yes, you did.
And what did you say?
That I was fine because we had a child together, that we needed to communicate because of the child. And we have set up a mutual friend to take care of the child in between transportations.
Okay. But you yourself don't have a problem with having regular contact with Nick?
Correct.
Thank you. That's it, Judge.
Okay.
Your Honor, if I may ask the victim some questions.
Yes, please go ahead.
Hi, Ms. Mittenmeyer, how are you?
Good. How are you?
Good. My name is ASG Tortorello. I represent the state of Georgia, and I'm prosecuting this case. Did you call the police on March 9th, 2022?
Yes.
And can you explain to the court what happened that day?
I was picking up my child she got sick at daycare. I had a friend that was going to watch her for me so I could go back to work and then come back home and take care of her. That's when my husband showed up and made his way into my home. I have an apartment that I pay for myself. I moved out in the intent of getting a divorce, and he made his way into the apartment and was trying to get into the apartment, and I was pushing him out.
Why did you guys have a dispute that day?
Because he wanted to get into the apartment. He thought that my friend that was going to take care of my daughter at the day was, I guess, a boyfriend or something, but it was a misunderstanding.
Okay, and did you advise the state that his acts of violence do stem from the fact that you do want to divorce him?
Yes.
Okay, and has any sort of violent acts occurred in the past other than this one today?
No.
Okay, and you are aware that you do not need to have contact with him, but you can just have a third-party transfer for your child?
Yes, that's what I set up, is a third party transfer so that we don't have to be, but if we need to communicate like on the phone for her purposes, for child purposes, then I can.
You understand a third-party transfer, though, requires you to communicate with that third party, and then that third party would then communicate to the defendant. You do not need to communicate directly to him.
Okay.
Are you okay with that?
Yes.
So are you telling the court that you do not want contact, but you're okay with third-party contact?
Yes.
Okay. Nothing further for this witness, Your Honor.
I do have one question. Mr. Heller mentioned a medical condition for Ms. Mittenmeyer. Will you have someone else who can assist you with that medical condition beside the defendant?
Yes, I do. I have plenty of family and friends around the area that can help me. I also haven't had any epileptic seizures in a couple years now.
Okay. All right. If there's nothing else, I'm ready to give my ruling. I'm going to rule that there will be a $5,000 surety bond, and that will be $4,500 for the battery, $5,000 for the cruelty to children. There will be a stay away from the address.
500?
I'm sorry.
500, yes.
Oh, what did I say?
5,000.
Oh, 500, excuse me. Take off a zero, 4,500 for the first charge of battery, 500 for the second charge of cruelty to children, for a total of 5,000. Okay. And there will be a stay away from 6105 Masters Way in Alpharetta. There will be no further contact with the victim, Lissa Mittenmeyer. In order to exchange the child for visitation purposes, there will need to be a third party identified who will coordinate between the two parties for that exchange, pickup, drop off, and visitation, so that the parents will not have any contact with each other. I'm going to order also that there be no drugs, alcohol, or weapons while on bond. And since you all were not residing together, I don't believe there needs to be a one-time escort or anything like that. I don't think the defendant should have any items in the home. Is that correct? Because you're already separated. Okay. All right. So that should be all that I need to take up today. Is there anything else from the state or from Mr. Heller?
Not from me, Judge.
Nothing from the state, Your Honor.
Judge, he has a question.
Yes.
I think my wife didn't understand the last question regarding contact.
You need to be very careful, Mr. Mittenmeyer.
I'm just asking a question.
Okay.
So originally she said she was willing to have contact so we could then coordinate to be able to deal with my 2-year-old daughter. And then I think when the state asked their question, I think maybe that may have confused her a little bit about the contact or not. So if you,
Sorry to interject, but I feel as though this is inappropriate. Any questions that the defendant has, he can ask for his attorney, but to try to ask the victim a roundabout question while she's on the line, he's not to address her. It's inappropriate and is clearly going to influence the victim's response. So I would ask that you direct him to direct any questions to his attorney.
Thank you, Mr. Walker. I definitely agree. Mr. Mittenmeyer, at this point, you are to have no contact by email, by Facebook, by third parties in any shape, form, or fashion with Ms. Mittenmeyer. If you do, you will be immediately arrested. So you need to govern yourself accordingly. And if you have to discuss any visitation with the child, this third party that Ms. Mittenmeyer has identified, she can send that information to your attorney, Mr. Heller, and he can coordinate and give you that information so that you do not have any conversations, contact calls, or contact with her at this point while you're on bond. Trying to make sure that you don't violate the conditions of your bond. Okay?
Okay.
All right. Thank you. That concludes this case.
Thank you, Judge.
All right. You may be excused, Mr. Heller.
Thank you.
Mr. Harkness, position 6 is next.
Okay. This is case number 22 CR 001460C. Mr. Mario Guevara Santos, charged with 1 count of DUI, less safe, or driving under the influence of alcohol, less safe.
You on who?
Number 5.
6, Mr. Harkness.
Thank you.
And we also have a visitor here. I believe it's the mother here.
All right, I see someone is at iPhone.
No, she's here at the courtroom in courtroom 2, Judge.
Oh, I'm sorry, down with you. Okay, in courtroom 2, and that's her name, Miss Harkness. And I guess you'll need to see, is she going to be addressing the court or not?
You want to speak? Okay. Yes, Judge, she would like to say something on his behalf.
Okay. All right. Let me call the correct case first. This is position 6, 22 CR 001452Y. Antonio Harkness, you're charged with 1 count of battery with the offense date of August 23rd, 2021. And what do you have pretrial?
It's his second arrest. He was arrested in 2020 for simple assault, family violence. It might have been amended to simple battery. Case number 20 CR 001568Y. That's a $2,500 pretrial bond. That's it.
All right. And this is Miss Salary's case.
Yes, Your Honor, Miss Salary.
Salary. All right, you may proceed.
Thank you, Your Honor. In this case, officers responded to 152 Grant Street in Fairburn, Georgia, in reference to a physical dispute. When the officers arrived, the victim, Maurice Killing, he's the stepfather of the defendant. The victim advised that he had just come back from the store when the defendant approached him very angrily. Your Honor, the defendant stated to the victim, quote, "You keep trying my mama," end quote. And then he punched the victim on the left side of his head. The defendant then swung at the victim again, but the victim was able to push the defendant back to avoid the blow. Your Honor, the victim did suffer a laceration to the left side of his head. This defendant's GCIC also includes a 2016 simple battery that was dismissed due to statute of limitation issues. However, the 2020 open case, that is a case where it's actually against his mother. His mother was the victim in that case. So I'm not sure if she should have any contact with him, being that he is on bond for that case with conditions of no contact. He does also have a 2021 FTA for that open case. Your Honor, he was given that pretrial bond just last year. So the state is recommending a $4,000 surety bond in this case with conditions of staying away from the incident location, no contact with the victim, 1-day anger awareness course, an FFIB, and no drugs, alcohol, or weapons while on bond. Nothing further.
All right. And
Yes, Your Honor, I'm sorry about that. Had to get a charger.
okay.
So Mr. Harkness is 19 years of age. He's currently unemployed. Your Honor, my understanding is that the stepfather does not reside at the incident location 152 Grant Street. However, if the court does not want the defendant to return to that location, he has provided an additional address where he could reside with his sister. That address is 3047 Middleton Road, Northwest Atlanta, 30313. Your Honor, the defendant is a lifetime resident of the state. You have heard the recitation of his criminal history. Regarding the open case, Your Honor, I would just ask the court to consider, of course, the presumption of innocence at this stage. I don't know his bond conditions. I don't know if he's supposed to have contact or not. But the court, if so desired, could inquire into that, and the state if need be, could take up whatever proceedings that they would like with that regard. Your Honor, we would ask for a signature bond on this particular case. I do understand the nature of the incident and the allegations. It sounds to me like a son taking up for his mother in some form or fashion. I'm sure his mother is here today and she could speak to that. Of course, I don't condone violence in any way, shape, or form, but I believe based on the circumstances, his actions may have been restrained. Your Honor, I do know the defendant doesn't desire or has a need to have any contact with the listed victim, so I think no contact is appropriate. We would just ask that he be allowed to go back to that location if the bond conditions don't already prevent him from doing so in the other case. If they do, then obviously, again, the state can take up whatever they need to with that regard. Nothing further, Your Honor, and the defense would not have anything to question the mother about, but of course, we would want to hear what she has to say.
Okay. And tell me your name, ma'am. I'm going to swear you in courtroom 2.
Shaquita Mason.
Again?
Shaquita Mason.
Ms. Mason, M-A-S-O-N?
Yes, ma'am.
All right, Ms. Mason, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. And again, you're the defendant's mom, Ms. Mason. And what can you tell me about this incident that is before the court today?
The stepfather, he have a drug problem, and every time we leave, he always assaults me. So Antonio came to just make sure I was okay.
What was the last thing you said? His what? I didn't hear you.
Antonio came to the house to make sure I was okay.
Okay. And so are you still in a relationship with Mr. Killing, the victim?
No, ma'am.
Okay. And so I guess the question is, you obviously don't have, or do you have any reason to fear Antonio Harkness, your son?
No, ma'am. And plus, I have ovarian cancer, so they only gave me 6 months to live. So that's why I really wanted him back on.
I'm sorry to hear that. Although I am concerned is because he's already on a bond in a separate case. Is that correct?
Yes, ma'am.
In that case, I believe was in 2021. Is that correct, State?
Your Honor, it was 2020, and
2020.
he did, yes, he received a pretrial SOB. So now the state is in a position where we feel as though a surety bond is appropriate for this matter.
Okay, thank you for that. All right, Ms. Mason, I do appreciate your time and coming down. I'm going to order a $4,000 surety bond. I'm going to order that Mr. Harkness have no further contact with Mr. Maurice Killings, the victim.
Yes, ma'am.
Not to go around him at all, Mr. Harkness. You see him come and go the opposite way so that you don't violate this bond. Also, I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order the one-day anger awareness course. And I think, is that all I need to take up on this case?
The stay away,
The
Your Honor,
attorneys?
from the incident location.
Oh, and well, the incident location, Grant Street, is that not where Mr. Harkness lives with his mom?
Yes, Your Honor, it is.
Right, so, and I've already heard that the victim will not be returning there. So I don't want to order Mr. Harkness to stay away because I don't think the issue would be his ability to go there. if Miss Mason has told me that Mr. Killings does not reside at that address, the 152 Branch Street, is that correct?
Yes, he don't reside there.
He does not.
No.
Okay. And so again, Mr. Harkness, if you go to your mom's house at this Grand Street location and Mr. Killing is there, then you need to leave. Okay, I'm not going to order you to stay away from your mom's house. Hope that you can be a help to her with the condition that she's under right now. And, you know, do all that you can to support her. Okay.
Okay.
All right. Thank you.
Thank you, Judge.
All right. Nothing further.
Next, we can go to position 5, our interpreter case, Mr. Guevara.
All right.
Your Honor, if I can just remind everybody to please pause so I can interpret accurate for Mr. Guevara.
All right. Raise your right hand for me. Do you solemnly affirm that you will faithfully interpret from Spanish to English and English to Spanish the proceedings before this court in an accurate manner to the best of your skill and knowledge with no embellishments?
I do, Your Honor.
All right, thank you. All right, this is case number 22 CR 001460C, State versus Mario Santos. Again, you're charged with 1 count of driving under the influence of alcohol is safe. Charged with the 2nd count of driving possession of open alcohol container, and a 3rd count of expired or no license on person, all with the offense date of March 15, 2022.
Señor Guevara, este es el caso que tiene usted, es el 22CL03767. Se le acusa de manejar bajo los efectos del alcohol y menos seguro para manejar. Se le acusa por tener un envase abierto de bebidas alcohólicas y se le acusa por no tener una licencia válida, y esto ocurrió el 15 de marzo de 2022.
All right, pre-trial, do you have anything?
I got first arrest.
Que es su primer arresto.
All right, sorry.
Yes, Your Honor. In this case, officers responded to a welfare call where the reporting party stated that a person was in the middle of the travel lane of a parking lot slumped over on the wheel. Officers.
Miss, sorry, can you please pause and start from the beginning?
I'm
Can you start
sorry.
from the beginning and then pause?
Okay.
Thank you.
Officers responded to a welfare call.
Los policías acudieron a una llamada de bienestar,
where the reporting party stated a person was in the middle travel lane of a parking lot.
donde la persona dijo que había una persona que estaba en el medio de en el medio del carril de manejo.
Slumped over on the wheel.
Que estaba dentro del carro y que estaba tirado ahí encima del volante.
Officers found the defendant in a vehicle unresponsive and slumped over.
Los agentes encontraron al acusado en este vehículo y no respondía y estaba como tirado en el volante.
It took multiple attempts to wake the defendant.
Se llevaron bastantes intentos para poder despertar al acusado.
When attempting to speak with the defendant, an odor of alcohol came from his breath.
Cuando trataron de hablar con el acusado, un olor de alcohol salió del aliento del acusado.
The defendant also had bloodshot, watery eyes.
Y también el acusado tenía los ojos inyectados de sangre, tenía los ojos aguados.
The officer noticed 2 open alcohol beverages in the center console.
Y en la consola central del vehículo, los agentes notaron que habían 2 envases de alcohol abiertos.
When asked for his license, the defendant stated he did not have one.
Cuando le preguntaron que mostrara su licencia, el acusado le expresó de que no tenía una licencia de manejar.
Due to the defendant's unstable disposition and language barrier,
debido a la situación inestable del acusado y debido a la barrera del idioma,
the officer did not perform fields.
El agente no llevó a cabo los exámenes que se hacen en el campo de sobriedad en el campo.
Implied consent was read and the defendant refused.
Se le leyó el consentimiento implícito, pero el acusado se rehusó.
Your Honor, in this case, the state is recommending a $2,000 surety bond for the DUI charge.
En este caso, su señoría, la fiscalía está recomendando una caución de $2,000 por el cargo de manejar los efectos del alcohol
$500 surety on each other charge.
y $500 en cada uno de los otros cargos como fianza.
An alcohol and drug evaluation.
Una evaluación de drogas y de alcohol.
No drugs, alcohol, or weapons while on bond.
Y no puede ingerir bebidas alcohólicas o drogas ni tampoco poseer armas de fuego mientras está bajo libertad bajo fianza.
Nothing further.
No, nada más.
Okay, Ms. Gant?
Thank you, Your Honor. Mr. Santos Guevara is 26 years old.
El señor Santos Guevara tiene 26 años.
He was born in Mexico, but has been in the Georgia area for the past 3 years with his dad and sister.
Él nació en México, pero ha estado en la área de Georgia por los últimos 3 años con su padre y su hermana.
He completed high school in Mexico.
Él se graduó de high school en México, de bachillerato o de prepa.
And he has been working for about 6 months with a tree landscaping and painting company.
Y en los últimos 6 meses ha estado trabajando con una compañía de arreglo de jardines y de pintura de casas.
He disputes the allegations and states that he was just getting off work and was tired.
Él disputa los alegatos que ha hecho la fiscalía. Dice que él acaba de salir del trabajo y que él estaba cansado.
In light of my client's negative history for any driving related offenses,
debido a la historia de mi cliente, que no ha tenido ningún otro tipo de infracciones o de delitos de manejar de tránsito.
And his language barrier in understanding any instructions for field sobriety testing.
Y también la barrera del idioma, de que no pudiera entender cualquier tipo de exámenes o de pruebas de sobriedad que se iban a hacer en el campo.
I am requesting a signature bond as he is recommended.
Y estoy recomendando que se le imponga una fianza bajo palabra, como se le ha recomendado.
We are opposed to the alcohol, drug evaluation and treatment at this time.
Nosotros nos oponemos a la evaluación y el tratamiento por bebidas alcohólicas y drogas en este momento. Nos oponemos a esa evaluación y a ese tratamiento.
If your honor determines that he is ineligible for a signature bond, then a bond of no more than $1,000.
Si el juez determina de que no califica para una fianza bajo palabra, se le pide al juez que le imponga una fianza de caución de no más de $1,000.
$500 for DUI less safe.
$500 por manejar bajo los efectos del alcohol de manera menos segura.
$250 for the open container.
$250 por tener un envase abierto.
And $250 for the expired or no license.
Y $250 por el cargo de tener una licencia no vigente o vencida.
Okay. All right, I'm going to give my ruling.
Voy a dar mi fallo.
And that is a $3,000 surety bond.
$3,000 de caución para la fianza.
$2,000 surety bond for the DUI.
$2,000 por el cargo de manejar bajo los efectos del alcohol.
$500 surety bond for the open container.
$500 de caución por tener un envase abierto.
And a $500 surety bond for the expired or no license on person.
Y $500 de fianza por no tener una licencia, por tener una licencia vencida o no licencia.
I'm going to order that there are to be no drugs, alcohol, or weapons while on bond.
Y que no puede tener uso de alcohol ni de drogas ni tener armas mientras está bajo libertad, por confianza.
And no driving while on bond unless you have a valid license from DDS.
Y tampoco puede manejar si no tiene una licencia válida que sea emitida por el DDS.
And that will conclude my ruling.
Y eso termina mi fallo.
there anything else I need to take up from either side?
¿Algo más?
Nothing further, Your Honor.
All right.
Nothing further from the defense.
Okay, that will conclude this matter. Thank you.
Concluye este asunto. Your Honor, may I be excused or you need
Yeah.
any more?
I don't think we have any more. Deputy, do we need the interpreter anymore? I don't think.
No, that was it, Judge.
Okay, thank you. You
thank
may be
you.
excused. Thank you for
Thank you,
your
Your
time.
Honor. You're welcome. Have a good day.
You too.
Next, we have position 15, Mr. Stokes.
Your Honor, there's a cross defendant with this case, so we would like to have a hearing together. Position number 13. Same facts.
Deputy, position 13, Ms. Simpson. She's not in courtroom 2, is she, or is she down at,
She should be in Union City.
all right.
They haven't logged on yet.
Yeah, they haven't logged on yet, Ms. Kim, so I don't know if we can do them together or not. We may have to repeat some of the things again.
Sure.
And Your Honor, if I may, the facts of this case that I'm about to put on record are not very long. So if I don't know if opposing counsel is okay with moving forward with Mr. Stokes, and then I don't know if that's okay with opposing counsel and with the court.
Yes, I don't think we have the ability in general to force them to get on at the moment. We may have some other things going on there, so we'll go forward with
Give
this
them a
one.
call. Did you need them? I
Can you call them and see if they're able to log on now? That would be fine. If they're not, we'll just go forward and have to come back.
Okay. Okay. They're logging on right now, Judge.
Okay, great.
So which position are we going with first, Ms. Simpson or Mr. Stokes, Your Honor?
We'll start with Mr. Stokes. This is case number 22 CR 001451A. State versus Joseph Stokes. You're charged with 1 count of simple battery family violence with the offense date of March 15, 2022. Do you have anything pretrial?
This is third arrest. Last arrest I have was 1998, disturbing the peace, out of Massachusetts.
All right, Ms. Tortorella.
Yes, Your Honor. The state's bond recommendation is as follows. For the simple battery family violence, a $3,500 surety bond. However, we're not opposed to a signature bond. The conditions be that he do not return to the incident location at 150 Peyton Place, and the street is spelled P as in Peter, EYTON as in Nancy, in Atlanta, Georgia. That he have no contact with the cross defendant, and her name is Monica Simpson. That he take a 1-day anger management course, no weapons, no drugs or alcohol, and no drugs and alcohol, and no new violations of Georgia law. Your Honor, on March 15th, 2022, Officer Norwood and Officer Witter of the Atlanta Police Department responded to 150 Peyton Place in Atlanta, Georgia, in reference to a domestic dispute. The officer spoke to the cross defendant, Monica Simpson, who stated she was pushed by the defendant, Joseph Stokes. The officers observed no injuries on the cross defendant, and these events did take place in Fulton County, Georgia. As you've heard, Your Honor, his last arrest was in 1998 for disturbing the peace in Massachusetts. He has 2 cycles out of Massachusetts and 1 cycle in Georgia. However, given his light record, Your Honor, and no violent offenses in his record, though we are recommending a surety, Your Honor, we are not opposed to a signature for this defendant.
Okay. All right, Ms. Kim? You're on mute.
Oh, Mr. Dark goes first.
Oh, I'm sorry, Mr. Dark. I apologize. Go ahead, Mr. Dark.
Yes, Your Honor. The defendant is 60 years of age. My understanding is he and Ms. Simpson have been or are romantically involved. My understanding is they are both on the lease, Your Honor, and they both reside at the residence. Of course, both of them were arrested. I would ask the court to strongly consider no violent contact. Based on even the allegations contained in the warrant, it sounds like nothing more than a push. She was arrested as well. I don't know the particular allegations against her in this case because we have not heard them yet. Your Honor, I do want to take or highlight for the court, the defendant does have a criminal history, but he has not been arrested in over 20 years, more than that actually. But he lived here, worked here, resided here. He works at the CNN building downtown. He's done that for the past 4 years. Very successful at his job, Your Honor. Very well liked, very well received. He is not someone with a propensity for violence. This is obviously not within his character, and his best evidence of that is his criminal history for the past 20 plus years. Your Honor, we would ask the court to strongly consider no violent contact amongst the parties and that they be allowed to return to the residence. Mr. Stokes particularly is pretty up in age and would not have the ability to really reside anywhere else if the court ordered him to stay away from his residence where he lives. So nothing further, Your Honor.
All right.
Your Honor, and just to add, if Mr. Stokes needs to return to the residence, I would ask that the cross-defendant not return. Given her record, which I'm about to go over, I do have concerns for both of them, but particularly this defendant. So that's why the state's requesting a no further contact, but I would defer to the court as far as the decision for that.
All right. Do you all want me to go ahead and hear position 13 and then make my ruling on each of them?
Yes, please, Your Honor.
Okay. All right. I'm going to call position 13 and hold on my ruling on Mr. Stokes. This is 22 CR 001450G, State versus Monica Simpson. You're charged with 1 count of simple battery family violence with the offense date of March 15, 2022. Pre-trial, do you have anything?
19 total. The last arrest was 2020 DUI, acquiring a license plate for the purpose of concealing identification. 2009 battery DV, dismissed out of Florida. Hold on. 2013, she was arrested and convicted for 2 counts of battery. That was out of Clayton County. Got an 07 probation violation, 07 battery conviction, 05 probation violation, 05 battery / simple battery family violence conviction. That's it.
Okay. All right, Ms. Kim.
Yes, Your Honor. Ms. Simpson is 58 years old. And
Your Honor.
Yes. Oh, I'm sorry. Ms. Tutorello, go first.
I'm sorry, Your Honor, I haven't gone over the bond recommendation. I apologize.
I
Ms. Kim.
apologize. That's my fault. Go ahead.
I'm sorry. All right, where was I? All right, so for the, this defendant, Your Honor, for the simple battery family violence, we are asking for a $5,000 surety bond. The conditions is that she do not return to the incident location at 150 Peyton Place in Atlanta, Georgia. That she have no contact with the cross-defendant, Joseph Stokes. That she take a 1-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law. Again, I'll be short on the facts that on March 15, 2022, Atlanta police responded to 150 Peyton Place in Atlanta, Georgia, in reference to domestic dispute. And upon arrival, the officer spoke to the cross defendant, Joseph Stokes, who stated he was pushed by the defendant, Monica Simpson. And the officers did observe no injuries on the cross defendant. And these events did take place in Fulton County, Georgia. Your Honor, the state is concerned, not precisely because of the facts of this case, Your Honor, but her history. You've heard from pretrial, she's had convictions out of Clayton County, battery, family violence on May 20th, 2005, Clayton County State Court, another conviction in 2007 for battery at a Clayton State Court. And then in 2013, she pled to battery twice, 2 counts of battery in Clayton County Superior Court. She has a battery arrest out of Pinellas County, Florida, which occurred in 2009. She was arrested for aggravated assault in Clayton County in 2001. That was dismissed. She has various violations of probations, stemming all the way back to 1992, mostly from Clayton County. She has a failure to appears on her record, and one that occurred on January 17th, 2001 out of Clayton County, Your Honor. For this reason, Your Honor, we are not recommending a signature bond due to her history and the risk of committing violent offenses, Your Honor, including felonies while she's out on bond, Your Honor. And nothing further from the state.
All right, Ms. Kim.
Yes, Your Honor. Ms. Simpson is 58 years old and she was born in Illinois. However, she came here when she was 3 months old. So she lived here in Georgia for almost all her life. And she has 2 daughters and she has siblings and she has a mother here. My concern is that she has a medical condition that she really needs to take care of. She has a disability right now. She's actually living off disability checks and officially diagnosed with diabetes, high blood pressure, and right now she has a bronchitis, which is very, very special vulnerable condition for especially COVID-19. So we are very concerned about her health at this point. And also high school, she graduated and she also has a 1 year of college. Even though she had 19 total cycles, however, the last conviction was 2013, almost 10 years ago, and 2007. Those are very remote. So we would like to request for signature bond since she has nobody else to pay for the bond at this point. And yet, we are not opposed to stay away from that location. Even though her name is on the lease, she's willing to move away because she understands the situation of Mr. Joseph Stokes. He has no other place to go, so she's willing to let him stay there and go to his mother's place. And she's fine with no further contact and other conditions of the bond. Thank you, Your Honor.
All right.
Your Honor, just to add, her last conviction was actually in 2015 for theft by shoplifting. I only read the relevant convictions, Your Honor, to you, but her last conviction was in 2015. She has been arrested for DUI most recently with no disposition on her GCIC. And nothing further from the state, Your Honor, only that you do, if you do give a bond, Your Honor, that'd be a surety, and we are recommending a $5,000 surety bond.
Your Honor, those are not violence related, Your Honor.
All right. Let me go back to position 15, Mr. Stokes. And Mr. Dark, are you there?
Yes, Your Honor, I'm here.
Okay. I don't see your camera, Mr. All right, I'm gonna, there you are. Okay, I didn't see you. I'm going to make my ruling on the Joseph Stokes case. On that position, I am going to order a signature bond in the amount of $3,000. signature bond through pretrial. I'm going to order that he have no further contact with the cross defendant, Ms. Monica Simpson. I'm going to allow him to return to the location of 150 Peyton Place as long as Ms. Simpson is not there. I'm going to order a one-day anger awareness course. And of course, no drugs, alcohol, or weapons while on bond. Is there anything else I need to take up on that case?
It's through pretrial, correct, Judge?
Yes, through pretrial. All right, and then on the case with Monica Simpson, position 13, I'm going to order a $5,000 surety bond. I'm going to order that you stay away from the location of 150 Peyton Place, not to return there, Ms. Simpson. You can take a one-time police escort or law enforcement escort to retrieve any personal items that you have there. But you are not to go back to that location yourself or alone at all. Take police with you for that one-time escort to remove your items. You're to have no further contact with the cross defendant, Mr. Joseph Stokes. No drugs, alcohol, or weapons while on bond. And you're to take the one-day anger awareness course as well. Anything else I need to take up with either of those cases?
No, Your Honor.
All right, thank you.
Thank you.
What kind of bond?
All right, who do we have next in courtroom 2?
We have position 4, Mr. Fegan.
This is case number 22 CR 001453E, State versus Daryl Fagan. You're charged with 1 count of battery family violence with the offense date of March 15, 2022. Do you have anything pre-trial?
This is 8th arrest. Last was back in September for DUI. As far as violence, he had a 2013 afraid conviction. I'll take him. I don't know why I didn't put him on the list.
Okay. All right, Ms. Sorry.
Yes, Your Honor. In this case, officers were dispatched to 300 Carpenter Drive, that's the Park Terrace Apartments, regarding a physical dispute. Immediately when officers arrived, they noticed large bruises on the victim's arm, forearm, and neck. The victim's name is Addison, Adyson, Schultz, Schultz. The victim informed officers that she went through her boyfriend, who was the defendant. She went through his phone and found out that he was cheating on her. When the victim confronted the defendant with this information, he punched her in the back of the head and then began to repeatedly hit her. Your Honor, as we've heard from pre-trial, this defendant does have a 2013 affray arrest. He also has a 2016 probation violation, which would make him at risk of not showing up back to court. Your Honor, the state is recommending a $2,000 surety bond in this case, with conditions of staying away from the incident location, no contact with the victim, and no drugs, alcohol, or weapons while on bond. Nothing further.
Okay. Ms. Gant.
Thank you, Your Honor. Mr. Daryl Fagan is 27 years old. He has been in the Atlanta area his entire life. He has family here, including a father and his sisters. We are opposed to the stay away at 300 Carpenter Lane. He is on the lease at that residence. I have been in contact with Addison Schultz. She states that she wants no violent contact. with Mr. Fagan. So therefore, I am requesting that Your Honor not issue a stay away and order a no violent contact order. Mr. Fagan has completed high school. He is working at a temporary agency. He works about 40 hours per week, and the name of the temp agency is Automation. He denies the allegations, Your Honor. He states that Ms. Fagan was actually yelling at her. He asked her to calm down. She pulled his hair and ripped 2 dreads from his scalp, and he basically was trying to get her away from him so that she could leave him alone. We heard about Mr. Fagan's history. However, his last conviction was in 2013, that is nearly 10 years ago. We did not hear about any FTAs. He has ties to this area, Your Honor. He is recommended for a signature bond. Therefore, I am requesting one today. And again, we are opposed to the stay away and would ask that Your Honor order a no violent contact order. Thank you.
Okay. All right, I'm going to order a $3,000 signature bond through pretrial. I'm going to order a stay away from the location of 300, I think it's 300 Carpenter Drive. I'm going to order no further contact with Addison Schultz. No drugs, alcohol, or weapons while on bond. And a one-time police escort to return to the location to retrieve any of his personal items. Is there anything else I need to take up in this matter?
Yes, Your Honor. Ms. Schultz states that she wants no violent contact. I was able to reach out to her.
Right, I think for her safety at this time, I do have some concerns. I'm gonna order no further contact. And for him to stay away from that location due to the evidence that are the information that I've heard today.
Thank you, Your Honor.
Mhm. Who do we have next?
Position 7, Mr. Knight.
This is case number 22 CR 001462J. State versus Jason Knight. You're charged with 1 count of battery family violence and a 2nd count of cruelty to children in 3rd degree, both with the offense date of March 15, 2022. Pre-trial?
His 5th arrest. Last was 2010 probation violation. I didn't see any violence.
Okay. All right, who do I have from the state?
Your Honor, I think that's ASG Sari's case.
Is it okay?
I'm sorry, what was the position?
Position 7, Jason Knight.
Okay, yes, that is my case. I'm sorry.
That's okay. You may proceed.
Yes, Your Honor. In this case, officers responded to 170 Boulevard Southeast in Atlanta regarding a physical dispute. They met with the victim, Shannon Donahue. Shannon is spelled SHANNON, Donahue, DONAHUE. The victim stated that she and the defendant were in a verbal dispute regarding him cheating on her when the defendant pushed her to the ground, struck her in the face, and then placed his hands inside of the victim's mouth and pulled her cheeks apart. The officers did note the victim had bruises on her knee, lips, and lacerations inside of her mouth. Your Honor, there was a minor present. Initial is J, last name Knight, KNIGHT. The defendant stated to the officer that he did indeed strike the victim in the past, and this entire incident regarding the police interaction was recorded on body cam. Your Honor, we spoke with the victim and she does not want contact with this defendant. She expressed being afraid of him. The victim also stated that the defendant had been violent with her multiple times in the past, and that the reason she didn't call the police was because the defendant would take her phone to prevent her from doing so. So, Your Honor, given that the state feels that the defendant does present a risk of reoffending and intimidating the witness, as well as he's a danger to this victim, the state's recommendation is a $5,000 surety bond on the battery, family violence, and a $1,000 surety bond on cruelty to children with conditions of staying away from the incident location, no contact with the victim, 1-day anger awareness, FIB, alcohol and drug evaluation. And Your Honor, that condition comes from the victim stating that the defendant drinks a lot and that is the source of his violence, as well as no drugs, alcohol, or weapons while on bond. And Your Honor, the victim, she is on the Zoom call and would like to address the court. Nothing further.
All right. Ms. Gant, do you want to go first, or would you like for the victim to go first?
I would like to present first, Your Honor.
Okay, go ahead,
Right.
Ms. Gant.
Thank you, Your Honor. Mr. Jason Knight is 35 years old. He has been in the Georgia area his entire life. He has a 5-year-old that he has an 8-month-old that he shares with Ms. Donahue. He also has a 5-year-old son from a prior marriage. He is actively working to gain full custody of his 5-year-old son, and that son visits him in the home at 170 Boulevard Southeast. We are opposed to the stay away. Mr. Knight is on that lease. He is the primary lease holder. I spoke to Ms. Donahue as well, and she informed me that she is in the process of moving out of that residence. Mr. Knight also informs me that she, meaning Ms. Donahue, would be unable to afford that home on her own, as he provides the financial means to maintain the home. He is a high school graduate. He also completed a union JTC apprenticeship program. He is a union agent for a sheet metal company. Regarding the allegations, he denies the allegations. He states that in fact, it is Ms. Donahue who consumes excessive amounts of alcohol. And when she consumes this alcohol, she wants to begin fighting with him. On this particular, as far as this particular incident, he states that she was becoming violent with him. He states that he showed her bruises that she apparently obtained because of her relations with another man. She states that he was merely trying to get her to calm down. He pushed her away from her. She stumbled and she began screaming, and he states that she placed her fingers in her own mouth and stretched her mouth and caused those injuries. He denies doing that. My client is recommended for a signature bond. Therefore, I am requesting that he receive a signature bond. I would ask this court not to consider any allegations that have not been properly charged and brought before this court. He is not a danger to the victim, Your Honor. We did not hear about any convictions for any violence whatsoever. We are opposed to a FIP that would be appropriate for someone who has in fact been convicted of battery. My client has not. And again, there is nothing that the state has presented that provides the basis for an alcohol drug and evaluation treatment for my client. And again, just to summarize, I am requesting a signature bond. If Your Honor determines that he is ineligible, then a bond of no more than $1,000. That would be $500 for each charge: simple battery, family violence, and cruelty to children in the third. And again, we are opposed to the stay away and would ask that Your Honor grant a no contact order. Thank you. A no violent contact order.
Okay. All right. Ms. Donahue?
And Your Honor, I do apologize for interrupting. I would ask that Ms. Donahue's testimony be limited to her wishes for contact, as this is not a trial.
And Your Honor, we would oppose that. Your Honor, this victim does have a right to speak, given the Bill of Rights, the victim's Bill of Rights. She has a right to be heard at any scheduled court proceeding, which is today, involving the release of this accused. So, Your Honor, we will ask the court to hear this victim's testimony.
All right. I will do so. Ms. Donahue, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, go ahead. At first, tell me about this incident that is before the court today. Is there anything else that you would like me to know about that incident?
Yes, ma'am. This incident was not about him cheating on me, nor me cheating on him. We were not together. We were living in the home as roommates until I found an apartment to get out, which I have. And he just felt uncomfortable with the point that I had already moved on and looked at me and did all of those things that was mentioned.
Okay, are you in fear of Mr. Knight?
Yes, ma'am.
Okay, and do you want to have any contact with Mr. Knight?
No, ma'am.
Okay, and so you have already moved from the 170 Boulevard Southeast?
I have not. I'm also currently on the lease. He is the leaseholder. So the appropriate thing for the other person saying that I can't afford it, that's a lie. I can prove bank statements that I can afford this apartment. I don't honestly want this apartment. I want to move on, but I need time. I need at least 2 weeks to get my things together into a proper place because we all know how leases work and how you move into apartments. You can't do it in a day. And I would just like to not see his face while I'm doing that.
Okay.
I would also not like him around my child.
Okay, so is this his child or just your child?
This is our child together, but he has also abused me in front of that 5-year-old that she's mentioned with autism.
Okay.
Your Honor, I would object. That 5-year-old is not the subject of the allegations before the court.
That's fair.
There is a cruelty to children in the 3rd degree. Who does that apply to? What charge? That is one of the charges?
Yes, Your Honor, that's the child that the victim and the defendant have together. That child is also a minor.
Oh, so there are 2 children.
No, Your Honor, there was only one child present.
Oh,
at
yeah.
the time.
And that is the 5-year-old?
No. I'm sorry, Ms. Donahue, go ahead.
That was the 8-month-old, not the 5-year-old. Sorry.
Oh, okay. Okay. I'm sorry. I did say an 8-month-old. Okay. That's what I was making sure of. All right. So there are 2 children in the home. Is that correct, Ms. Donahue?
They're not cohesively there together. He gets his son 1 week on, 1 week off.
Okay. I got you.
But sometimes, yes, they are there together.
Mhm. But your child, the 5-year-old, resides with you full time.
No, that's his child. It resides with him and his ex-wife, 50-50. My 8-month-old is with us constantly.
And I'm sorry, that's what I was getting the 2 children mixed up. You have the 8-month-old. Okay.
Yes.
I'm
Yes,
sorry
ma'am.
about that. Okay. All right. I'm going to go ahead and give my ruling. And with that ruling, I'm going to order the $6,000 bond, which will be a signature bond through pretrial. And with that $6,000 signature bond, it will be $5,000 on the battery, family violence, and $1,000 on the cruelty to children, for a total of $6,000. I'm going to order that Mr. Knight stay away from the location, the apartment at 170 Boulevard Southeast. I'm going to order that he have no further contact with Ms. Shannon Donahue. And I'm going to order that he have no drugs, alcohol, or weapons while on bond. I'm going to order the 1-day anger awareness course. And if he is granted any visitation with his 8-month-old child, that be done through a 3rd party. Ms. Donahue, if you're going to allow any visitation, then that needs to be done through a 3rd party so that they can set up the drop-off, pickup, or any issues regarding visitation, so that, again, with you having no further contact, you're not to be in contact with him regarding visitation, okay?
Okay.
I'm going to order again that Mr. Knight, that you stay away from that location while you're on bond. And I'm going to order the 1-day anger awareness course through pretrial. You need to take that course as well. So you cannot return to that apartment. I will give you a one-time police escort to return to get any personal belongings that you need to get from the location. All right? You're raising your hand.
Your Honor, Mr. Fagan, I'm sorry, Mr. Knight, remain silent. Your Honor, if I may clarify your ruling. As I understand it, Ms. Donahue is in the process of moving out of the residence, right? So are you asking, are you ordering a stay away for the entirety of the time that he's on bond, or until she removes herself from that property?
Let me ask Ms. Donahue, is there any way that you would be able to let him know? You said you needed a couple of weeks or maybe a month to move, because he will probably be on bond much longer than that.
Yes,
is there
ma'am.
any way that you have a third party that could inform him?
Yes,
or
ma'am.
inform his attorney?
I have a third party. One of his coworkers or one of my coworkers can let him know. I also had his friends come remove every single being of his things. So he has no reason to bring a one-time police officer. All of his stuff remains with James Knight or James Jackson, his coworker. All of his things, anything he ever needs.
Well, Your Honor, I would still request a one-time law enforcement escort just to ensure that he is able to confirm that all of his belongings have been removed.
Yeah,
I agree.
Yeah, that's usually customary, Ms. Donahue. So we will allow him that one-time escort. Now, if he shows up at the door and does not have the law enforcement with him, then you are not to let him in. He can be reminded he's violating his bond. So he can't show up there without that escort. Once he takes inventory of his items from James Jackson, then there may be something that's missing, and the police will be there to regulate any type of moving of any items that he believes are still there that are his. Okay. Now, the other question I had is, when you move out, are you able to let the same third party, James Jackson, know?
Yes, ma'am.
That you have moved out? Okay. And so let me amend that. And I can write it on here, that if he has notification that Ms. Donahue has moved out from the location, then he can return to take possession. And Ms. Donahue, Ms. Gant, do you want her to give it to you or to Mr. Jackson, or both?
I'm sorry, what is your question, Your Honor?
The notification that she has moved out and he's able to return. Would you like for her to contact you to give you that information as well, or not?
Yes, Your Honor, and I will be happy to reach out to her to give her my number. She has it. I called her earlier.
Okay. And so
I don't have it saved, but yes.
Okay, don't have it saved. Okay, so reach back out to her if you could. I'd prefer that possibly, to help Ms. Gant as well, that you get her email and that you can just email her a notice so that she can then have it in writing that you have agreed that you vacated that location and he is free to go there. I think for the protection of both of you, put it in writing.
Yes.
Okay. All right. Is there anything else I need to take up in this matter?
Nothing further. And I see, Mr. Knight, unless you have a question about your bond condition, I would advise that you remain silent.
All right.
Oh, yeah, I think I do. I want to make sure where I could get the information for the anger management, so I could, is it going to be on paperwork when I'm released or something else?
You will get it through pretrial. When you report to pretrial, they will give you the information on the course that you need to take.
Okay, thank you.
Okay.
Can I also say one more thing before?
Yes, Ms. Donahue.
He has a key fob that they cannot deactivate to this apartment. I don't feel comfortable. If that could be confiscated, that would be great, and sent back to this location, that would be great.
Yes. Until Ms. Donahue moves out of this location, Mr. Knight, are you able to leave it at the rental office or somewhere, the key fob to that apartment, until you take possession of it again?
Yes, ma'am, as long as she can return. That's where my mailbox is as well. If she could just return.
Absolutely.
Okay. So if you will do that, and I will add that to my order, that you will return the key fob to the rental office and keep it there until you maintain your possession at a later date, okay? All right, thank you. Good luck to you all.
Thank you.
Your Honor,
Yes.
regarding position 4, I
Uh-huh.
would like to inquire the courtroom too, if he is still in the courtroom.
Deputy, can you hear us?
Daryl Fagan.
Is Mr. Fagan still in the courtroom?
Yes, he is.
Yes.
Yes.
Your Honor, I do not believe that I communicated to the court that I opposed the stay away at 300 Carpenter Drive, but I'm looking at my notes here, and if I'm not mistaken, I believe that Mr. Fagan informed me that Ms. Schultz left that property or has moved from that property, and that he is the person that is on the lease. Your Honor issued a stay away, and I would just like to clarify that with him so that he doesn't have a permanent stay away from his own residence.
Your Honor, we did hear Ms. Gant's objection to the stay away, but it was still ordered.
Yes. I was concerned, I believe also about the incident that occurred. And, you know, I don't know if there needs to be any amendment to it to say if the victim has given information or permission that she's vacated the apartment, that he can take possession similar to this case. Is that what you're trying to say, Ms. Gant? Is similar?
Yes, that's what I'm requesting, because I don't want him to be permanently banned from returning to his own residence.
What do you say to that, Ms. Sowery? If the victim gives information to Ms. Gant in writing with email, Ms. Gant can reach out to her again and have it in writing. Do you have any objection to him returning if she has already vacated that location?
Your Honor, I would not have an objection to that, but you've already made your ruling on this, so I would just ask the court to move forward with the ruling that's already been stated, unless we don't have any information at this moment to change anything, and you've already made your ruling, so we would ask the court to move forward with the ruling as made.
And Your Honor, if I may, I am merely advocating for my client. I'm bringing it to the court's attention while he is present before you. I stated that I neglected to share that information with the court. I'm advocating for my client and would ask that you amend the ruling if we can confirm that she has either left or is planning to leave the residence.
Your Honor, we've already heard Ms. Gant's objection to the stay away. Your Honor, you imposed the stay away due to safety concerns for the victim. So we would again ask that the order stay as made.
Have you all had any contact with the victim, Ms. Sowery?
Your Honor, we reached out and left a message to her.
And are you directing that question to me as well, Your Honor?
Have you, I think you said, Ms. Gant, you had spoken to her or not?
Yes, Your Honor, I have spoken to her.
I'm going to leave my ruling as it is. I wish, you know, she had been on the call. This situation was a little different because I did have the victim on there who confirmed that she's in the process of moving. And it's a little difficult when I haven't had a chance to talk to the victim to find out if that is true or not. So I don't want to put her in jeopardy or put her in any harm's way if I've not had a chance to examine her for myself to find out if that is true. In this present case that we had, Ms. Donahue was on the line and was able to state that that was her intentions to move. So I felt a little more comfortable about that one, okay? So I will leave the ruling as it stands on Mr. Fagan's case.
Thank you, Your Honor.
Thank you.
Next, we have position 1. That's going to be Mr. Ashford Jesse.
This is case number 22 CR 001455F. State versus Jesse Ashford. You're charged with 2 counts of cruelty to children in 3rd degree, 1 count of battery family violence, all with the offense date of July 28, 2020. Pre-trial.
19 total. 2019 probation violation, possession of cocaine. 2019 convictions for 8 counts of financial transaction card fraud. He had a 2019 ag assault on robbery, hijacking a motor vehicle, theft by receiving, driving without a valid license, possession of a knife or a firearm during the commission. Those are dismissed, if I'm not mistaken. 2018 probation violation. 2018 failure to appear was NOD. 2017 failure to appear NOD. Probation violations from 2017. He went to felony earlier and got a $25,000 good bond. Those 2 battery, second or subsequent offenses, and felony, they reduced those to simple battery, just a FYI.
Okay.
But his total felony bond is $25,000 good. That's it.
All right, Ms. Solomon.
Yes, Your Honor. In this case, officers were dispatched to the Central Park Apartments located at 2900 Camp Creek Parkway regarding a physical dispute. The victim, Christiana, CHRISTIUNA Suggs, she advised that the defendant got physical with her because she would not let the defendant take her vehicle. When the victim attempted to take her keys from the defendant, he struck her in the face. The victim sustained a swollen eye and scratches on her neck and back. The defendant did leave the scene before officers arrived, and all of these acts did occur in front of 2 minors, one initial C Suggs and the second J Suggs. Your Honor, as we've heard from pretrial, this defendant does have a history of FTAs. He has a history of probation violations as well. I count at least 2. And Your Honor, the case that he appeared for today in felony court were against these same victims that we have today. Therefore, Your Honor, the state does feel that this defendant does present a risk of reoffending. He's a flight risk, and he does present a risk to intimidate the witness, being this case and the felony case. Your Honor, the state's recommending a $4,000 surety bond on the battery family violence and $2,000 surety for each cruelty charge, with conditions of staying away from the incident location, no drugs, alcohol, or weapons, and no contact with the victim. Nothing further.
All right, Ms. Camp.
Thank you, Your Honor. Mr. Jesse Ashford is 25 years old. He has been in the Atlanta area his entire life. He shares 2 children with Ms. Suggs, a 5 and 4-year-old. He also has custody of 2 of his 2 other children from another relationship. He does not receive child support for those children. We are unopposed to a stay away. Mr. Ashford states that he has not seen Ms. Suggs in 3 years. He denies the allegations. The matters that are before us are for an incident that occurred July 28, 2020. He states that he was not in contact with her at this time and that his mother and sister are able to provide an alibi for him. Mr. Ashford completed the 12th grade. He is currently working construction with his uncle when he is able to work. He works no more than about 20 hours per week. Again, he denies these allegations, Your Honor, and I acknowledge my client's history. However, the last violent offense that I heard about was 2019, and that was actually dismissed. He informed me also that for the FTAs and probation violations, he was incarcerated at that time. Your Honor, we heard that he received a very high bond in felony today, and given his limited financial means and his adamant denials of even being in contact with this witness, and also the length of time that it took to actually bring him to answer to these charges, he stated that he was pulled over twice before, and these warrants did not come up, or this particular warrant did not come up. That's in July for the event that occurred in July 28, 2020. Your Honor, for these reasons, I am requesting a signature bond. If Your Honor determines that he is ineligible, then I would ask for a low bond, and that would be a bond of $2,000, and that would be $1,000 for the battery, family violence, and $500 each for the cruelty to children and the third charges. Thank you.
All right, I'm going to order a $6,000 surety bond, $4,000 on the battery, and $1,000 on each of the cruelty charges, for a total of $6,000 surety bond. Stay away from the incident location, 2900 Camp Creek Parkway. No further no further contact with the victim, Christina Suggs. Mr. Ashford, you need to stay away from the victim. Do not go around or near her, please, as well as the children. If there's going to be any visitation that is allowed, then that needs to be facilitated by a third party. You may have law enforcement escort to return to the property one time to retrieve your personal belongings. And no drugs, alcohol, or weapons while on bond.
Your Honor, he informs me that the complaining witness, to his knowledge, back in 2020 did not, he states that he doesn't, given the length of time that given the amount of time that he has not been in contact, he doesn't have any belongings at 2900 Camp Creek Parkway, so he will not need a one-time law enforcement escort.
All right, we'll take that out of the order. Is there anything else I need to take up on this matter?
Nothing from the defense, Your Honor.
All right, thank you.
Next, we have position 10, Mr. Morris.
Francois, number 2 bonded out, right?
Yes.
Okay. Is that the only one, Deputy?
Yeah, that's the only one that bonded out.
Okay, thank you.
You're welcome.
This is position 10.
Yes,
22.
Mr. Morris?
Yes. 22 CR 001445E. Mr. Morris, you charged with 1 count of battery family violence and a 2nd count of simple battery family violence, both with the offense date of November the 4th, 2021, pre-trial.
This is 3rd arrest. He was arrested on the 11th of this month for suspended license, 2014 theft of services, misdemeanor possession of marijuana.
All right. Ms. Tartarello?
Yes, Your Honor. The bond recommendation is as follows. That for the battery family violence, it would be a $4,500 surety bond. For the simple battery family violence, a $3,500 surety bond. So the bond total will be an $8,000 surety bond. The conditions is that he do not return to the incident location located at 1155 Welch Street Southwest in Atlanta, Georgia, 30310. That he have no violent contact with the victim, and her name is Maya Wu. That's MYAWU is the last name. That he take a 1-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law while he's out on bond. Your Honor, on November 4th, 2021 at around 5:01 p.m., an officer W. Agenor, and for the record, that's AGEN as in Nancy OR, of the Atlanta Police Department was dispatched to 1155 Welch Street Southwest in Atlanta, Georgia, in reference to a child abuse call. On arrival, the officer spoke to victim Maya Wu, who said the defendant Edward Morris picked up their child from school that day at around 4 p.m. The victim advised that their daughter misbehaved in school, and the defendant was aware of this. The victim further stated that when the defendant arrived at the residence around 4:20 p.m., he picked up a small tree branch and started to discipline the child. The child's initials, Your Honor, are LM with the branch. Victim advised she attempted to stop the defendant from striking their child by removing him from the house. Victim advised that while she and the defendant were outside, the defendant grabbed a broomstick and struck her. The officer observed a visible bruise on the victim's left hip. The victim advised the officer her daughter had no visible injuries. Ms. Wu advised that though she didn't want to press charges, Your Honor, to the state, she wants to restrain an order against the defendant. The victim was shown a photograph of the defendant and made a positive identification, and all these events occurred in Fulton County, Georgia. Your Honor, this defendant has 3 cycles, as you heard from pretrial. He's had 2 prior arrests. On one was for theft in 2014, and the other, which is the most recent one, is a traffic offense, Your Honor. However, it does reflect that he poses a risk of reoffending, whether violent or not, while he's out on bond. And therefore, because he has a record, Your Honor, we are recommending a surety bond of $8,000. And furthermore, Your Honor, we understand that the victim wants contact due to the fact that they do share a child together. And so based on the history, Your Honor, I am okay. The state is okay with a no violent contact, given that the victim has stated this to the state. And she is online, Your Honor. So if I believe the victim does want to speak.
Okay. All right, Ms. Kim, would you like to go first?
Yes, Your
For
Honor.
the victim? All right, go ahead.
I'll do it first, and then I'll let the victim talk, testify. Mr. Morris is 24 years old, and he has been here in Georgia for all his life, 24 years, and his entire family is here. He has 3 children, and he has parents and siblings here in Georgia. He's also self-employed, Your Honor, as a cleaning technician. He has been doing that for about 2 years, and what we have to notice is that he was actually incarcerated in Atlanta prison for 7 days, and then he was transferred to Fulton County for 1.5 days. So he has been already incarcerated for 8 days, 8.5 days. So we would like to request for the credit given for those long incarcerations, and he does need to. He could not work for during all that time. He does not have income. He could not have any income while he was in jail. So we do need he needs signature bond. And Your Honor, also I believe that the minor child did not have any visible injury at all. There was no actual violence against her. I believe that Georgia, it is legal to have a reasonable discipline as a parent to correct the child, as long as it is reasonable, and there was no visible injuries here. So we would like to request for signature bond. And also, Mr. If Your Honor is not inclined to give him signature bond, we would like to request for surety bond no more than $2,000, Your Honor.
Your Honor, if I may rebut, as far as credit for the incarceration, Your Honor, I've never heard of any such credit during a bond hearing. I've heard of credit maybe for a plea, Your Honor. As far as no actual violence, there has been an actual violence that was committed here, not only against the victim, but her daughter, and it was not reasonable discipline, Your Honor. I do not, the state does not feel that picking up a branch and striking a child is a reasonable form of discipline, even with or without injuries, Your Honor. And again, we do stress that you give a surety bond on this matter. And Ms. Wu's on the line, Your Honor.
Your Honor, I just want to clarify one thing. There was no striking here. Thank you, Your Honor. Ms. Wu.
Thank you.
Please.
All right, Ms. Wu, can you unmute yourself? Okay. Ms. Wu,
Yes.
can you raise your, hi, would you like to address the court today?
Sure.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yeah.
Okay, put your hand down for me. All right.
Okay.
Now I want
One,
you
can
to
I let
only
you know
talk about this incident. Go ahead.
my name was spelled wrong. It's Maya.
Oh, Maya. Okay.
Yes,
And then your last name is Wu, W-U.
correct.
Okay. All right. And what would you like to tell me about this incident in regards to Mr. Morris?
One, I never did tell the officer that he picked up a branch. I told him it was a switch, and I believe he had on a camcorder when he was talking to me. So I never said he whipped her with a branch. I told him it was a switch. In my opinion, it was a fairly large switch. But then again, I've never been whipped with a switch, so I wouldn't know what a switch was supposed to look like. But it looked like it was too thick of a switch for him to whip her with.
Okay. Are you in fear of Mr. Morris?
Am I in care of him?
In fear of him?
Oh, no, not at all.
Are you in fear for your children if they were around Mr. Morris?
No, his children love him.
Okay. And so you stated that you want no further violent contact with Mr. Morris?
That's correct.
Do you want him to return to the location at the 1115 Welch Street?
I'm not opposed to him coming and dropping his kids off at my house. I'm not opposed to him coming and picking up his kids from my house.
Okay, he does not reside with you at the Welch Street address?
No, ma'am.
Okay, he does not reside there. Okay. And so you think you can facilitate visitation without a third party involved?
Yeah, but if need be, my grandmother is always available, and he knows that.
Okay, she resides with you?
She literally lives like 2 houses down from me.
Okay, okay. Well, what I'm going to do is I'm going to order a signature bond through pretrial in the amount of the $8,000, which would be $4,500 for the battery and $3,500 for the simple battery. So that's an $8,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order that there be no further violent contact with you, Ms. Wu. I'm going to not order a stay away from that location since he does not reside there. But I'll trust what you say regarding exchanging of the children with either you or your grandmother to make sure again that the children are safe if you are going to allow that. But normally, since they are partial victims in this case, I would order no further violent contact with the children as well. So I'm going to do that a little different, even though there's not any cruelty charges regarding the children, but I want to make sure that they're going to be safe if you're going to allow them to be in his care.
Yes, ma'am, always.
Okay, so let's make sure of that. And Mr. Morris, you understand that? I'm going to allow you to have visitation if Ms. Wu wants to allow you for that. But there's to be no further allegations or anything, no further violent contact with the children. I'm going to put that in my order to make sure that does not happen, or else you would be violating your bond. Be careful if you're going to speak, because again, the state is listening. You have a right to remain silent if it's just a general question. Otherwise, I know Ms. Kim is going to ask you not to speak about this incident.
Yes, ma'am. I just have a simple just statement.
No, you are Mr.
I thought you had a question.
Signature bond. Is it a question about the bond? Otherwise, I strongly recommend you not to speak.
No, I'm saying, don't worry. I'm not gonna say that. Don't even worry about it. Don't even worry.
Thank you.
So this is no further violent contact?
Yes.
I got that.
All right.
Your Honor, are you going to impose a 1-day anger management course for this defendant?
Yes, I did. I believe I said it, but I will repeat it again.
You did.
Okay.
Yes, you did.
It's on there. But I'm also adding no further violent contact, Mr. Toussaint, with the victim. And it's Maya, it's Maya. That's correct. Okay, with the victim, Maya Wu, as well as the children in the home. And those children in the home do belong to Mr. Morris, is that correct?
That's correct.
Okay, all right. Is there anything else I need to take up?
No, Your Honor, nothing further.
All right, thank you.
Thank you.
Mr. Marby, position 8 is next.
Avery.
All right, this is case number 22 CR 001443Y. Mr. Looks like Quinez Mabry. You're charged at 1 count of simple battery family violence with the offense date of March 15th, 2022. Do you have anything pre-trial?
First arrest, first arrest.
Okay.
Your Honor, the state's recommending for the simple battery family violence a $3,500 surety bond. The conditions that he do not return to the incident location at 949 Harwell Street, and that's spelled HARWELL Street, Northwest in Atlanta, Georgia. That he have no contact with the victim, Jamecia Favors, her first name spelled JAM as in Mary, ECIA. Last name is Favors, and she's present here at the Zoom call. A one-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law while he's out on bond. Your Honor, on March 7th, 2022 at 3:30 p.m., the victim, Jamecia Favors, went to the Atlanta Police Department, Zone 1 precinct at 2315 Donald Hollowell Parkway in Atlanta, Georgia. The officer, T. Jenkins, was there and he spoke to the victim at the location. The victim advised that she had just been assaulted by the defendant, and I'm sorry if I butcher his first name, Quinez Mabry, Quoinez Mabry, who is the father of her child and her boyfriend. The victim advised the incident occurred at 949 Harwell Street, Northwest in Atlanta, Fulton County, Georgia. The victim further advised that both she and the defendant were arguing about the relationship when the defendant became angry, grabbed her body, and slammed her to the floor. After the defendant slammed her to the floor, he began to punch her in the face and head at least 3 times with a closed fist. The victim advised that she was able to leave the home that they share and come to the precinct to report the incident. The officer did not observe any injuries on the victim. The victim was then transported to 3909 Campbellton Road in Atlanta, and the street name is spelled Campbellton, to retrieve her infant child that she left at the home. The defendant had taken the child to a relative's home following the incident and did so for the victim to pick up the child at that location. The victim confirmed the defendant's identity from a Georgia driver's license photo. Your Honor, I understand he has no, this is his first arrest, but the violent nature of what occurred here is concerning. That's why we're not recommending a surety bond, a signature bond. The victim, Your Honor, had to, just based on the fact she did not feel comfortable enough to call from her own home, she had to leave and go to a police station to make such report, Your Honor. And this is evident from the facts of this case. And therefore, Your Honor, based on what we've heard here, the state is uncomfortable consenting to a signature bond and that he have no further contact with the victim. Nothing further from the state.
All right, Ms. Gant.
Thank you, Your Honor. Mr. Mabry is 25 years old. He has been in the Atlanta area in his entire life. He shares a 3-month-old with Miss Jamecia Favors. He also is the primary caretaker of 2 minor children, one age 7 and another age 6. He is not receiving any child support. We are opposed to the stay away at 949 Hartwell Street. That is Mr. Mabry's residence. He also lives there with his mother. Mr. Mabry completed 12th grade. He has interviewed for a I guess, a position in a culinary arts training program. He is currently employed at True Green Lawn Services and Uber. He started this job last week, therefore he does not really have the means to pay a lot toward bond, Your Honor. He does not have any prior violent criminal history. He denies the allegations, and regarding the state's contention regarding the violent nature, my client is presumed innocent. He denies these allegations, and there were no visible injuries on Ms. Mabry. And again, he is presumed innocent. Therefore, Your Honor, I am requesting a signature bond on Mr. Mabry's behalf. Again, we are opposed to the stay away. I was able to speak with Ms. Jamisha Favors, and she states that she wants no violent contact. This incident happened on March 7th, and they have resumed their relationship and are co-parenting their child together. Thank you, Your Honor.
Your Honor, the state has not been able, I'm sorry, let me see what I think I have some notes for her.
Okay.
She states that she's present too, she can speak as well. She provided to us that she's not currently in a relationship, that they do not currently live together. So given this, Your Honor, they share one child together. The victim stated that she does not fear for the defendant, and that this is the first time he's hit her. We understand all this, Your Honor. I'm still not comfortable granting her contact. If they have children, they could have a third party transfer. If in fact that she does not live there anymore, that he have a one-time escort to make sure that she's not there anymore, and then that he can return to the incident location. Even though the victim does not have any injuries, the charge in and of itself, simple battery, family violence, is concerning. He did strike her. So, Your Honor, for this reason, we are not consenting to a signature bond.
Okay. And my victim, Ms. Favors, victim in this case.
Your Honor, the state's witness is on as Jamesia Favors.
Yes.
Yes, Ms. Favors. Okay, there you are. Can you would you like to address the court?
Yes.
Okay, I'm gonna get you, yeah, okay. The sun is kind of in your eyes, and so you have pulled over and are not driving, is that correct?
Yeah, I'm in a apartment.
Oh, I see, you're in parking lot, okay. All right, raise your right hand for me.
Could you see me?
Now I can. You have someone else in the car with you?
Yeah, and she took her now.
Is that your child? Is that a minor?
No.
It's an adult?
Close the door.
Do they have anything to do with the case? Because I don't really want someone else listening to the testimony.
She got out the car.
Okay, thank you. All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. What would you like to tell the court today about this incident?
I mean, it happened already, so I don't know what y'all gonna do about that. But I'm not afraid of him or anything. This is his first time ever putting his hands on me, and I would like to continue contact because we do have a 3-month child, and I wasn't able to have contact with my dad, and I don't want my baby to grow up and not be able to see her dad all that just because of one mistake. And I do believe it was a mistake, and I believe that he won't do it again. And I'm not scared of him though at all. I don't have no fear for him.
Do you have any fear for your 3-month-old while the child would be in the care or custody of Mr. Mabry?
No.
And how long have you been together?
A year and 4 months now.
You stated that your child is 3 months old.
Yes.
Is it a boy or girl?
It's a girl.
Okay. And again, with this location, the 949 Harwell Street, who resides there?
He do. I don't live there anymore.
Oh, you've already vacated that location?
Yes.
Okay. And is that a lease or does he own that home?
Lease is his mom home.
Oh, it's his mother's home. Okay. So he and his mother reside there.
Mm-hmm.
Okay. And so you would not be returning to that location, correct?
Correct.
Okay. And do you think you all can exchange visitation with your child without any incident?
Yes. We have been in contact ever since it happened, due to the fact that he called and said that he wanted to see his child. So he's been seeing her.
Prior to his arrest?
No, well, he got arrested yesterday. So yeah, prior to his arrest. Yeah.
Okay. Because you scared me a little bit there. I thought, well, he couldn't have visited yesterday. Okay.
Yeah, I know.
I understand. Okay, so let me do this. There's nothing else from either attorney, I'll go ahead and give my ruling.
And Your Honor, he's recommended for signature bond.
Okay.
Your Honor,
All
if I
right.
can ask the victim some questions.
Oh, yes, I'm sorry, Ms. Tartarello.
I'm
I
sorry.
didn't ask you that. Go ahead.
Did you advise the state that you guys were together or were no longer together?
Well, I told them that we have been together as in like being around each other, but we're not in a relationship right now.
Okay. So do you know that with a third party contact, you do not have to have contact with them? He could still see his child through the third party contact. But do you want to pursue a third party contact, or are you saying that you don't want any violent contact with him, and you do want to maintain contact?
Yes, I do want to have contact, but just no violent contact.
Okay. And have you had any prior history with him, and anything that showed that he acted violent towards you in the past or recently?
No, because I'm real big on domestic violence, so he don't do that type of stuff to me because I'm real big on that.
Okay, nothing further, Your Honor.
Okay. All right, I'm going to order the signature bond in the amount of $3,000 through pretrial. I'm going to order the one-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order no further violent contact with the victim, Jamesia Favors. And I'm going to, and I guess that would be it. I'm not going to order a stay away from the incident location, since that is the defendant and his mom's home, and the victim states that she does not reside there. And I won't put a third party in place unless the victim feels that she needs to do that. You assure me that there's not going to be, and Mr. Mabry, if you assure me there's not going to be any more violence, then I won't order a third party with the visitation exchange at this point. All right. So that should conclude it unless the attorneys have anything else.
Nothing further from the defense, Your Honor. Your Honor, this concludes my business. May I be excused?
Yes, you may, Ms. Gant. Thank you.
Thank you, Your Honor.
All right, Ms. Favors, you may be excused. Thank you.
Okay, thank you.
Last case, Judge, is position 11 and 12, Mr. Pierre.
Okay. All right. Hold on 1 second. All right. These are the last two cases, positions 11 and 12. Deputy, let me ask one quick question before we begin. Position 14, Stanford Smith, is that someone who's bonded out? I do have that position on the calendar. Do you have that person?
Let me look at the calendar. Okay, Smith Stanford, position 14 is gonna be a reset, medical reset.
Okay.
And also position 3.
And then I think we have one more, position 3.
Yes, Your
Position
Honor.
3 is in Union City. They'll be going next. And
Oh,
then-
okay. Okay, that's fine, but that's it for you in courtroom 2. I was just making sure we hadn't missed anything.
Okay, and then you also know position 2 has been released.
And yes, got it. Thank you so much.
You're welcome.
All right, this is case number 22 CR 001446C. State versus Gregory Pierre. You're charged with 1 count of simple battery family violence with the offense date of May 3rd, 2020. And I have a second case, 22 CR 001448C. Again, you're charged with 1 count of battery family violence with the offense date of December 31st, 2021. Both cases on the calendar, positions 11 and 12. Do you have anything pre-trial?
He got 37 adult arrests. History out of South Carolina, Florida, and Alabama. He got forgery convictions, probation violations, uttering counterfeit bank bill. So basically, passing counterfeit money. That's what's out of Florida. The forgery out of South Carolina. What else? He got a probation violation out of Columbia, South Carolina. 2018 fleeing an officer, obstruction, misdemeanor possession of marijuana, fugitive from justice, 2 counts, acquiring a license plate for a purpose of concealing. 2014 probation violations for obstruction. 2013 FTA, forgery, 4th degree conviction, 2013. He had a battery DV that was DWAP from 2011. I don't think I saw any other adult violent history. Yeah.
Okay.
Yeah.
All right, Ms. Tartarello.
Yes, Your Honor. If I may, I would like to read the bond recommendations and the fact patterns, and then I'll just go over his history and then reasoning, if that's okay. I'm not sure how you would like me to proceed.
No, that sounds fine.
Okay. For his first case, Your Honor, with the simple battery family violence, the state's recommending a $3,500 surety bond. The conditions is that he do not return to the incident location at 178 Buena Vista Avenue. That's the street name is spelled B as in boy, U-E, N as in Nancy, A, and Vista, V as in Victor, I-S-T-A, Avenue Southwest in Atlanta, Georgia. That he have no contact with the victim, Brittany Owens, her first name spelled B as in boy, R-I-T-T-N-E-Y. Owens is spelled like the traditional spelling. 1-day anger management, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on May 3rd, 2020, an Officer C. Smith of the Atlanta Police Department was dispatched to 178 Buena Vista Avenue Southwest in Atlanta, Georgia, in reference to a dispute. Upon arrival, the officer met with victim Brittany Owens, who advised that she and her roommate, defendant Gregory Pierre, got into a verbal dispute which ended physical. The victim advised the officer the defendant struck her twice on the right side of her face. The victim further advised there was a third party present, a LaSasha Matthews. For the record, LaSasha spelled L-A-S-A-S-H-A, and Matthews is a traditional spelling, who witnessed the incident. Officer observed no visible injuries on the victim, and these events occurred in Fulton County, Georgia. Your Honor, for his second case, we're recommending for the battery family violence a $4,500 surety bond. The conditions that he do not return to the incident location at 5630 South Monte Vista Drive, The street name is spelled Monte, Vista, and then Drive Southwest in Atlanta, Georgia. That he have no contact with the victim, Monica Dix. The last name is spelled Dix. That he again take a one-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, in this case, on December 31st, 2021, a Corporal M. Cooper of the South Fulton Police Department was dispatched to a 5630 South Monte Vista Drive Southwest in Atlanta, Georgia, in reference to a domestic dispute. Upon arrival, the officer made contact with the victim, Monica Dix, who advised that she and her boyfriend, defendant Gregory Pierre, that her boyfriend had choked her and slammed her on the sofa. The victim further advised that she was sick with COVID and she went to ask the defendant to help around the house. The victim stated the defendant was ignoring her request and the defendant told the victim to get away from him. The victim refused and the defendant threatened to punch the victim with a closed fist. However, the defendant instead grabbed the victim by the arm and neck and threw her on the sofa. The victim advised she was trying to get away from the defendant as he was choking her and she pulled his hair. The officer observed that the victim had bruises on both her arms and laceration on her neck, and these events did occur in Fulton County, Georgia. Your Honor, the state has some concerns, and we are not recommending a signature bond for this. He's been convicted of 2 felonies. They're forgery charges out of South Carolina. In 2007, he pled to carrying a concealed weapon and carrying a pistol without a license. And he also pled in 2017 to grand theft auto. He's been arrested for several felony arrests out of Ohio, a 2021 felony arrest, counterfeiting, no disposition on his record, not that I saw. A simple battery arrest out of Fulton County in 2006, a 2004 armed robbery arrest out of Florida, a 2004 homicide murder arrest out of Broward County, Florida, battery family violence out of DeKalb County, various violations of probation, 2018 a violation of probation at Bay County, Florida, and a 2005 violation of probation out of Broward County, Florida, 2019 violation of probation out of South Carolina, several FTAs, one in 2007 out of DeKalb County, 2013 out of failure to appear out of Fulton County, Your Honor. Your Honor, he's a multi-state offender, so definitely his record does reflect that he poses a risk of reoffending while he's out on bond, and not only reoffending, but committing felony offenses. To add, Your Honor, we do have concerns for both of these victims. And he's also shown, Your Honor, that he's able to commit violent offenses. He has 2 victims here, one in 2020, Ms. Brittany Owens, and the other in 2021, Ms. Monica Dix, Your Honor. And for these reasons, Your Honor, we do feel that the surety bonds I've just stated to you are more than reasonable.
And what was your recommendation on the second case with Ms. Dix, your bond recommendation?
Yes, Your Honor. The bond recommendation for her is a $4,500 surety bond, and the conditions for him not to return to the incident location, to have no contact with the victim, to take a one-day anger management course, no weapons, no drugs or alcohol, and no new violations of Georgia law.
All right, thank you. All right, Ms. Kim.
Yes, Your Honor. Mr. Gregory is 37 years old, and he has been here in Georgia for 17 years. He has 3 children, 10, 4, 2, and he has been working as a forklift operator at DHL Supply Chain for the last 2 or 3 years. And he has a GED, and actually after this, there's a hold from South Carolina, so he will be actually transported to South Carolina. So there's going to be no flight risk. And considering the previous histories, we do understand that state wanna do this surety bond, and we would like to request for the minimum surety bond because of his low income at this point. So $1,000 to $2,000 surety bond is requested. And one thing though, for Monica Dix, the second case, where the victim or no complaining witness is Monica Dix, and she is actually mother of the baby. They have a child together. So we would like to request for third party child visitation for that child. That's it, Your Honor. Thank you.
Your Honor, the state will not oppose to third-party transfer. And as far as a flight risk, Your Honor, given the fact that he does have a hold in South Carolina, he does pose a flight risk just because we do not know when he will return to Georgia for his court proceedings. And nothing further from the state.
Okay. All right. On the first case, position 11, which is the case ending in 446C, I'm going to order rather 3,500 surety bond. I'm going to order that he stay away from the incident location, 178 Buena Vista Avenue. I'm going to order no further contact with the victim, Brittany Owens. I'm going to order no drugs, alcohol, or weapons while on bond. That would be my ruling for position 11. Position 12. I will again order the $3,500 surety bond. Stay away from the incident location, 5630 South, I think it was South Montreal or Montreal, Monte Vista.
Monte Vista, yes.
Monte Vista. South Monte Vista Drive. No further contact with the victim, Monica Dix. I'm going to order, although he's to have no further contact with Ms. Dix, that yes, there should be a third party transfer for any visitation that is allowed with the child, and no drugs, alcohol, or weapons while on bond. And I think that should be it for both of those cases. Anything else?
Judge, what was the bond amount for the position 11 again?
3,500 surety bond.
Okay,
For
so-
both cases, actually, 3,500 surety bond on both.
Thank you.
Uh-huh.
Ms. Kim, he has a question.
Be careful on your question. Ms. Kim will direct you.
Yes, is it only for, unless you have a question about the bond itself, I strongly recommend you to stay silent.
I've already been receiving help from one of the people, not Brittany. She's already got my property, came get my car at the impound. We did not know nothing about this. But she is who I get help from. I don't have any kids by her or anything. I have 3 kids, but she helps me. And I just don't understand where this comes from, but I get help from her. I just send her money and she just helps me. That's it. I can stay away, but I know I receive. She's the only one that really helps me.
Okay.
That's all I ask, just so I can continue just to receive help from her, just only her.
Can we do no further violent contact, Your Honor?
Your Honor,
You can call her if you want.
Your Honor, the state will strongly oppose. He has a case against her. She's not here to talk. She hasn't stated that, she, and then let me double check my notes before I speak on the record. Miss Monica Dix did state that she does not, she wants no further violent contact, but given the facts of the matter, Your Honor, we strongly oppose this, and given the fact that she's not even here to testify.
Right, I will do just the same that I did in the previous case. If I don't hear from the victim, they're not here, I'm not going to order any contact at this point. So it will remain no further violent contact, Ms. Kim, as I've ordered before. And I do hear your point, Mr. Pierre, but again, And the victims are called. Right, no,
You said no violence.
I'm sorry, no further contact. Let me stand corrected. On both cases with both victims, you'd have no further contact with either victim. But I want to make sure that you understand that, Mr. Pierre, you would be violating your bond if you go around either of these two women. I understand what you stated about her helping you, but she is not here to do that. And actually, I was getting ready to tell you that both sides, the PD and the state, they contact these victims and they do speak with them when they're able. So I don't have any information that we should allow that. So we're gonna stick with no further violent contact, okay? I'm sorry, no further contact, no further contact.
Just came up here and I just signed over my property and stuff.
Mr. Gregory,
I
strongly
have nothing
recommend
to
you
do with what you did in that regard.
Okay.
Talk to your attorney. You're able to make bond, and your attorney may be able to assist you in those matters, okay? All right, thank you. No further contact.
Thank you, Your Honor. Nothing further.
All right, thank you, Judge. We're completed here in courtroom 2.
All right, thank you. Have a good one.
Thank you, you too.
Okay, we on our last one.
The last one over in Union City, South Annex.
How you doing, Your Honor?
I'm good. How are you?
I'm good. We have a Miss Emmert. I think I'm pronouncing it right or wrong. Not sure.
Yeah, please forgive us.
I'm so sorry.
That's okay.
She's position number 3.
Gotcha. All right, this is 22 CR 001449. Is it Rebecca and is it Emmert or Emhert? Emmert. Okay, thank you. You're charged with 1 count of battery family violence with the offense date of March the 12th, 2022. You have anything pre-trial? First arrest. Gotcha. All right. Ms. Sorry?
Yes, Your Honor. In this case, officers responded to 43015 Gardner Drive in Alpharetta regarding a physical dispute. When officers arrived, this defendant stated that she had to fight for her life. She stated the cross defendant struck her in the nose with his fist. The defendant admitted that she and the cross defendant began to fight, but she did not state who started the fight. And this defendant and the cross defendant, they formerly lived together, making this battery family violence. Your Honor, the state is recommending a $2,000 signature bond in this case with conditions of stay away from the incident location, no contact with the cross defendant, 1 day anger awareness, and no drugs, alcohol, or weapons while on bond.
Give me the name again of the cross defendant.
Yes, Your Honor, it's Justin Chamberlain. Last name is PHAM.
Thank you. Okay.
You got it.
Got it. All right, and your bond recommendation amount is?
2,000 signature bond, given her history and the nature of this case is a dual arrest.
No objection, Your Honor. We agree.
Okay. I was gonna say Mr. Dark, and that was quick and easy, right?
Right. I keep it simple. I got
it. All right, so I'm going to order a $2,000 signature bond. I'm going to order, as far as the incident location, Ms. Emmerich, do you live at that location?
Yes, that's my home.
It's your home?
Yes.
And the victim, cross defendant rather, Justin Chamberlain, does he reside there with you?
He does not.
He does not?
No.
Do either attorneys have any information to the contrary?
No, Your Honor. Information I have is what she just stated. And also that she has lived there for, I think, about a year. And she works in Marietta, has for the past 9 years.
Okay. All right, great. All right, so I will not order a stay away from your location. But I'm going to order that there be no further violent contact with the cross defendant, Mr. Justin Chamberlain. Do you all have any children together? No? Okay. All right. Is there anything else? Oh, no drugs, alcohol, or weapons while on bond? And I think that is it, unless the attorneys tell me I have anything else that I need to take up.
That is all, Your Honor.
Okay.
Nothing further from the state.
All right. Thank you.
That's it.
Is that the last one?
Yes, ma'am. That'll be it for South Annex.
All right. Thank you. Take care down there.
Yes, ma'am. Thank you.
Okay.
Okay, Judge, are we ready to go over the calendar?
Goodbye, pretrial. Have a good afternoon.
Judge, are we ready to go over the calendar?
Yes, let me give you this last one.
Okay,
Yeah, hand you this one.
okay.
Thank you.
All right, good afternoon. Again, the reset date for SAP is going to be March the 29th. Position number 1 is reset to the SAP calendar with a $6,000 total good bond. Position number 2 bonded out, so therefore is reset further notice. Position 3 is reset further notice with a $2,000 SOB through pretrial. Position 4 is reset further notice with a $3,000 SOB through pretrial. Position 5 is reset to the SAP calendar with a $3,000 total good bond. Position 6 is reset to the SAP calendar with a $4,000 good bond. Position 7 reset further notice with a $6,000 total SOB through pretrial. Position 8 reset further notice with a $3,000 SOB through pretrial. Position 9 is going to the SAP calendar with a $5,000 total good bond. Position 10 reset further notice with an $8,000 total SOB through pretrial. Positions 11 and 12, they both are going to the SAP calendar and they each have a $3,500 good bond. Position 13 is going to the SAP calendar with a $5,000 good bond. Position 14 is being medically reset for tomorrow. And position 15 is reset further notice with a $3,000 SOB through pretrial. Are there any questions, comments, or otherwise?
Nope, I think you got it. All right, everyone, have a good afternoon. Thank you. All right, bye-bye.
Bye.
Bye-bye.